Welcome, everybody. I'm going to give folks a few minutes to join, and then we will get started. And as Gia just put in the chat, there will be a recorded version that we will circulate around afterwards. Great. Well, I will go ahead and kick it off because I think we've got a full agenda here. Welcome to our special session on cannabis intellectual property strategies. I'm really excited to have this discussion and grateful to have Vicente's Intellectual Property Counsel, Erich Veitenheimer and Chelsea Spencer here with us. They're some of the, in my opinion, best IP counsel in the country, and I focus specifically on cannabis and psychedelics issues as well. And I think it's really unique and opportune timing to have this discussion, with everything that's going on and the three industries we all focus on, cannabis, psychedelics, and hemp, and with potential rescheduling on the horizon for cannabis, and then psychedelics thereafter, and or in some cases maybe sooner, and also with the significant growth and developments in the hemp market. And just as far as the run of show, Erich's gonna kick it off and outline some of the key patent considerations. As I mentioned, Erich is our IP counsel specific to patents, and has worked with folks across multiple sectors, with pharmaceutical, botanical, cannabis, psychedelics, and developing patents and patent strategies. And Chelsea is our IP counsel specific to trademarks, which has been a really interesting state and federal practice to navigate over the years, and is based in Texas. And many of you know my colleague Andrew Livingston, who's our director of economics and research here at Vicente, and he's going to be moderating with me and help guiding the questions to hopefully have a really in-depth and informative conversation here. So we'll definitely have time for questions at the end for the audience here. And if you have questions that pop up as you go along, feel free to put them in the chat, and we will get to them at the end. And with that, I will turn it over to Erich to go through the kind of patenting 101 to set the stage here. And just to kind of set the table for the discussion, the patent and trademark intellectual property legalities, are assessed based on, in part, this legal status of substances under the Controlled Substances Act. And as many of you know, currently substances including marijuana, ibogaine, DMT, LSD, all these psilocybin listed here are currently classified as Schedule I controlled substances, meaning they have no accepted medical use and treatment and a high potential for abuse. Next slide. And in Schedule II, you'll see substances like fentanyl, methadone, cocaine, drugs that have a high potential for abuse, but do have accepted medical use with or without severe restrictions, and can be prescribed with very stringent regulations and not over the counter. And we'll be talking about mostly substances in these categories, and as we'll unpack, the legal avenues are relevant to the schedules here, as are the legal avenues potentially relevant when schedules change. So Erich, we'll turn it over to you to take it from here.
Hi, everybody. And so what's interesting about this is if it is rescheduled from Schedule I to Schedule III, it doesn't change anything as far as what you can get patented. In fact, illegal substances can be patented and are patented in the United States. And I wanted to give you a couple examples here. The first two are actually clients I helped get their patents for. For CBD, GW Pharma issued patents covering Epidiolex as early as April 24th, 2018. Priority applications going back as early as 2015. But this patent was issued prior to the president signing the Farm Bill into law on December 20th, 2018, and also issued prior to the FDA approval of Epidiolex on September 28th, 2018. So you see the scheduling of CBD did not matter here as far as patenting went. It mattered as far as the ability to sell the drug. And then if we look at THC, there are literally hundreds of thousands of patents and patent applications out there now on various aspects of marijuana, including delta-9 THC. And the first patent, which I helped work on with my team, was to germplasm expressing greater than 0.3% delta-9 THC, which issued on August 4th, 2015 to Biotech Institute. And as you know, THC is still a Schedule I drug. So here we have it, a patent's been issued on that. The same thing can be said for psilocybin, where you have the crystalline psilocybin patents that have been issued to Compass Pathways, which was also a client of my previous firm. And we could say that for others too, such as MDMA. Next slide, please. And so I just wanted as background to look at, patentable products that are made by or derived from plants. And, the one we're talking about the most here is drugs. And that can be a substance intended for the use in the diagnosis, cure, mitigation, treatment, or prevention of a disease. And it can be chemical or biological. And I've given you some examples here of biological ones. I actually worked on the Colchis crocus one. And then the CBD one we've been discussing, and then there's paclitaxel, cineketchicins, all of which are under drugs. And as you can see, some are biological. And then other examples of patentable products made by plants would be nutraceuticals, where you provide some physiological benefit, echinacea, green tea, folic acid, or dietary nutritional supplements, which are products added to the diet, such as vitamins and minerals. And then foods, any nutritious substance that animals or people eat. And then finally, it can be everything else, fiber, timber, rubber, fuel. And that's where hemp would fall now, right? Since it's been descheduled. But CBD has not been descheduled, as we'll talk about a little bit more as we go. And so, it's been descheduled, but the FDA is still maintaining purview over it because it's an approved drug. And so what we have here is what's going to change if we go from Schedule I to Schedule III is the drug category. Again, not the ability to patent them, but the ability to get them approved by the FDA and to sell them. The categories here, nutraceuticals, dietary, nutritional supplements, and food would still fall under the, possibly fall under the Controlled Substance Act and also under the Federal Food, Drug, and Cosmetic Act. And so those do not necessarily get approval at the FDA letter, unlike the drugs, if in fact we go from Schedule I to Schedule III. Next slide, please. And if we look at patentable subject matter around cannabis, there's the active pharmaceutical ingredient, which is the drug we're talking about. That's a drug substance. It could be a single chemical entity. It could be a synthetic chemical entity, or it could be a botanical drug, which is by definition plant materials, algae, microscopic fungi, and any combinations thereof. And this can include complex mixtures for the botanical drugs. Then another patentable subject area category is the formulations and compositions for the drug. And that's where the active pharmaceutical ingredient, botanical drug is mixed with other components to increase its delivery and efficacy. And also methods of using, such as administration, treatment of diseases, et cetera. And you're going to see in a minute why these categories are important as regards what happens if there's descheduling. Next slide, please. Going on with the patentable subject matter, there's also devices for administering, such as inhalers, patches, and needles. And I think, as some of you know, there's the FDA's been pretty strict about approving inhalers, and that was Biosciences, when they came out against them and their product on the market, they said that the CBD could cause spasms and toxicity of the airways. And so there's been some issues around that as far as trying to get inhalers out there on the market for these drugs. Methods of making, and then finally, if in fact it's a biological material that originates from a plant, then we can get claims on the plant genetics and the germplasm. There's 3 types of formal intellectual property protection in the United States for plants, the only place in the world that's true. That's utility patents, plant patents, and plant variety protection or plant breeders' rights, and you can actually get all 3 on the same invention if they qualify. The latter one, the plant variety protection, is administered by the USDA. Next slide, please. And so what are the advantages of getting pharmaceutical patents? We know we can get the patents, the patent office will issue them, but if there is a descheduling, then what is the advantage here? Well, the patent itself grants a limited term monopoly, right? So it provides an exclusive right to exclude others from making, using, importing, and selling the patented invention for a limited period of time. That's true whether or not it's descheduled. And it hopefully provides freedom to operate if we're not dominated by the patents of others. And if, in fact, it gets descheduled, then it may be lawfully dispensed by prescription if FDA approved. And the advantage there, of course, is the insurance reimbursement for the user. But importantly, on the interplay between patents and the FDA, if it's descheduled, then it can be listed on the FDA's Orange Book. And you can list on the FDA's Orange Book patents claims that cover the drug substance, such as the API or the botanical drug, the drug product, the formulation composition, and or the approved method of use. Those categories are what can be listed on the Orange Book. If it's listed on the Orange Book for an FDA-approved product, then generic competitors must certify every patent listed on the Orange Book for that product. And they must file for certification, and that will constitute an act, can constitute an act of patent infringement. If the patentee then, the patent owner, then files suit within 45 days, the FDA will postpone the generic drug approval for 30 months. You have 30 more months on the market, so you can see what the big advantage is here with the descheduling and the fact that now that you have to these, you actually have the ability to enforce them at the federal level, and then also it gives you this 30-month stay for generics to move in. Next slide, please.
That's my cue. So today we're talking Trademarks 101. If you'll slide to the next slide for me. Let's start with the basic threshold of what a trademark is. Everyone knows that when you walk in the grocery store, you may see 100 different brands, and you as a consumer are going to be drawn to the particular brands that you have used in the past, those that you trust, that you know if you purchase it, it's going to be the same standard, the same quality that you've used for years. That's something we call goodwill on the trademark side. It's always what you're aiming for, and you can earn that in any word, phrase, symbol, device, or combination of those things that identifies goods or services. This is where a lot of people get confused. They'll come to me and say, "Hey, I want to trademark my business name." And I say, "Well, what's your business name?" ABC123 LLC. Okay, what do? We're behind, Green Towel Cannabis. Completely different thing there. The goods themselves would be branded under Green Towel. The business itself is ABC123 LLC. The portion of that that's eligible for protection is the portion that consumers identify as the source of your goods and services. So when you're seeking to register a trademark, your first threshold question is always going to be, is this what consumers identify as my source of my good or my services? You might be surprised. We also have what we call sensory marks or non-traditional trademarks. I've listed a few on here, the famous Tiffany blue, Louboutin. That is his actual specific red Pantone color. That's on the bottom of those hills. The NBC chime, the Harley Davidson sound of a muffler going on when I don't have on there. If you have heard a commercial from, a large company and it gets stuck in your head for months, like Nationwide is on your side, forgive my singing voice, that is a registered trademark. Scent. We have strawberry toothpaste as a scent. There's actually an engine oil lubricant that comes in strawberry or lemon lime. Those are registered trademark. Hasbro Play-Doh. There's also product trade dress. These are a little bit more difficult to achieve. I've done both of these on product and interior and exterior trade dress. For product, when you think of products trade dress, the Coca-Cola bottle. Even if I took the label off with the red and white, you would still see those cylindrical designs at the top, the shape of the bottle, and you could probably tell me that was a Coca-Cola bottle. When you divorce the non-functional aspects of that bottle, the fact that it has an open spot on the end for you to drink from, you're left with design elements that Coca-Cola has intentionally put on that bottle so that you, the consumer, know it's still Coca-Cola even without that brand name. On interior and exterior trade dress, if you've ever walked into a retail store and thought to yourself, why in the world does every Apple store in the entire pretty much world look exactly the same? There's a reason for that. They want consumers to immediately know that this is an Apple store, even if you don't see the logo out on the outside. That is an example of an interior exterior trade dress. That's utilized a lot by retail services industries, wedding venues. I've done one for wedding venue. Restaurants. One of the seminal cases was 2 pesos with Taco Cabana. And in the United States trademark law, if you ever have any question, it's all specifically laid out in the Lanham Act, which lays out the basis for registration and reasons for denial. So for purposes of today, as you've heard, we're pretty much focusing on cannabis, hemp, psychedelics. And as you've now heard, both cannabis and psilocybin remain in Schedule 1. So how does that impact the trademark side? I wish that I could say, as Erich did, not in the foggiest, but unfortunately not. So next slide, please. In the United States, we have at the United States Patent and Trademark Office something called the lawful use rule. And I'll be very frank with you, in my opinion, it is something that the Trademark Trial and Appeal Board made up in the 60s. It came from, I can go over a lengthy history, but there were 2 specific rules on registration of some dairy and meat products, and it somehow transcended into the lawful use rule. As stated in the Trademark Manual of Examining Procedure, the office says that if the mark itself violates federal law, then it will be refused registration. This has really been a thorn in my side for 10 plus years of my practice at this point, because examiners have used this to become experts on everything from the Pesticide and Rodenticide Act, the Controlled Substances Act. They've become experts on certain oil and gas regulations. And if they deem in their sole discretion that it's a violation of federal law, then you are issued a denial. They get this from this little quote on the first bullet point in the Lanham Act. They're pulling it solely from these words: all commerce that may lawfully be regulated by Congress. That's an issue for me and a lot of other practitioners, because Congress regulates unlawful conduct every single day. It's why we have the Controlled Substances Act. But the Trademark Office looked at it and said, well, it says only that which is lawfully regulated, so this is a bar to registration here. Interestingly enough, this prohibition has never been directly challenged at the federal circuit or going up to the Supreme Court. There was a pending case called M. Ray Joy T that I was incredibly excited about. It was challenging the ability of an intent to use application to proceed, where the applicant had a bona fide belief that, for example, cannabis could be rescheduled. Unfortunately, that case fizzled out. If this is of interest to you, this is a law review article. I was so excited to see this come out, because if you've ever seen me on a webinar before, you know I've been griping about the lawful use rule for probably a broken record at this point. So if you have some additional time, check out that law review article. He thoroughly dissects the tenuous basis that the lawful use rule rests on. And I think it is absolutely ripe for a challenge at the Court of Final Review for here. So I thought it would be helpful today if we looked at an actual cannabis brand to run through a case study on how I would help you protect your cannabis brand if you come seek us out at Vicente. So I'm based in Texas. I thought Willie's Reserve, I see a question there. Is it behind a paywall? No, it's not. You can find that for free anywhere on the internet, and I can probably have Gilly put a copy of that in the chat. So everybody knows Willie Nelson. As a native Texan, I'd be remiss if I didn't use Willie on every time I chat about trademarks. I vacillate between Willie and Stoop, but today we're getting Willie. I always tell people it took me forever to find a copy of the logo on the right that didn't have the registered trademark symbol on it. And that's because, next slide, please. Willie's counsel did their job, and he holds 1, 2, 3, 4, 5 federal registrations. I verified last night; they're all still active. And so you're saying how? Because this is a plant touching enterprise. These are actual cannabis goods. So one of the primary registration strategies that I pursue for my cannabis and psychedelic companies who are ineligible for registration on the goods themselves that include the prohibited substances are ancillary registrations. So for example, Willie here has some smokers articles, which include rolling paper, cigarette lighters, things like this. He has stickers, clothing, any of the eligible categories that we can get cannabis companies in. Another one that we can do is if you have an informational section on your website that includes consumer information about your goods. What is THC? What is CBD? Give me some dosage information. There are certain services classes that we can get you in. But for the goods themselves, you'll see Willie's got some loose flower over here, which would be in 34, pre-rolls in 34. Actually, I think these are all his smokable products. Absolutely no chance that we would ever be able to get registration on those products because they are Schedule 1 substance in the United States and forbidden from registration. So what do we do about those goods themselves? You should be pursuing state registration within your relevant state. It can be a little bit more difficult because each state has their own requirements that may differ from the United States Patent and Trademark Office requirements. And they don't have what we call the intent to use application that sort of acts as a placeholder for name registration. I did have to update this slide. Willie needs to speak to his counsel because the last time I did this registration, all of his Colorado registrations were current. They've all expired. They may have compelling reason for that. I don't know, but I checked last night. He is still selling in Colorado. It didn't have any active registrations on that. So next slide. What lessons can we learn here from Willie? Federal registration, always of tantamount importance if we can get it for you. 9 times out of 10, a competent cannabis trademark IP counselor or psychedelic counsel can absolutely assist you with that into getting onto the registry. And the benefit of that is if I have a second comer to the market, another cannabis company come to me and say, let's use green towel again. Hey, I want to do green towel. And let's say I've never heard of green towel. And they tell me, oh, I want to do gummies and a seltzer. Most cannabis attorneys, or excuse me, most trademark attorneys who do not have experience within the cannabis or hemp realm are going to run the relevant classes for those, which are food goods and beverage goods. A cannabis attorney is going to know I'm not going to find the results that I need in green towel. And I'm not saying not to run those classes. I would do that anyways. But I'm also going to run the categories that I would expect to see cannabis companies in, those ancillary categories that I spoke about. And that's not something someone well adept in this industry would think to run a website services category for a cannabis company. So they could miss that. This is why state registrations also become so important. Cannabis is obviously bounded by interstate psychedelics as well. They should not be crossing interstate lines in commerce. So seek registration of the state registries. I put a special note on here on policing knockoffs. We've really seen, particularly in the cannabis industry, but there's an emergence in psychedelics as well for large food companies. I'm amazed at the amount of people that I see coming into this industry who think they're doing something parodical or satire by making a product that appears to be or puts a play on word on a major brand. You'll see here like Stony Patch or Double Stonio. You will get a cease and desist faster than you can put this on your website. And there's absolutely nothing that someone like myself or Erich or any other IP professional in the entire United States can do for you. The brands are focusing on dilution and tarnishment, saying, you know, you're not making a parody of our brand, you're diluting it and you're tarnishing it. So it's very important with IP. There's 3 things we really focus on. We clear, we protect, we enforce. By clear, that's when you bring your name to me and say, hey, we're thinking about this. And I say, slow down. Let's go clear the domestic. Let's run a domestic clearance search and clear the mark first. Because a lot of times when I run a full United States clearance search, something may not come up at the USPTO. It may come up in a state law registry or it may come up in common law use. There is no requirement in the United States to register your trademark. You're not forced to do so. So there are a ton of companies who have been out there for, 30, 50, 2 years, doesn't matter, who have priority. Then you kind of get into geographic priority disputes, which we would need a much longer webinar to chat about here. I put a note on priority disputes here because this is something we could have a 2-3 hour webinar on here because this is the part that is absolutely fascinating to me. It's going to be very pertinent for hemp, and we'll talk about that when we get to the hemp slides. But for cannabis, we have yet to see a state versus state cannabis trademark infringement dispute reach final adjudication. We've seen several that have been filed. They settle out of court. They're dismissed, but we don't yet know, like, let's take my green towel again. There's a green towel company in California and a green towel company in Nevada. They're in close proximity, but those goods cannot cross state lines. So is there a chance of consumer confusion? What would a court do with that? Who holds priority when we reschedule? And that's the biggest question on everyone's mind. So next slide, please. Let's chat about rescheduling. Rescheduling is the greatest thing that will happen to my trademark career. It will make my job phenomenally easier. And people say, why? Well, right now, I cannot get you registration on a cannabis inclusive product, period. Nothing that I or anyone in the United States can do. When it is rescheduled, as Erich noted, it becomes eligible for pharmaceutical drug category. So presuming a brand goes or a company goes through the proper mechanisms to reach FDA approval, and I'm not going to postulate on that. I'm not an FDA attorney, but you go through the process, file your IND or your ANDA, and you're approved for a pharmaceutical drug. Boom, the USPTO has no bar at that point. I shouldn't say no bar there. My office is a bit unpredictable lately, but presumably has no bar. So I put an example here of a Schedule 3 drug that is live on the register. This is a male testosterone treatment that you can use. You can see they've got the circle R symbol on the actual product itself. And on the right, that is a copy of their actual registration. It is a lawful good in U.S. commerce. The trademark attorney behind the filing here, presuming there were no other bars to registration, had a very solid, smooth path to registration. So for the trademark side specifically, rescheduling is going to be quite helpful to the industry, in my opinion, because it makes the subject matter that was uh, completely ineligible for registration potentially registrable at that point. Next slide. So now let's talk about the bane of my personal existence on a daily basis, which is hemp derivative trademarks. People always ask me, which do you think is more difficult, hemp or cannabis? And I do not hesitate when I say I think hemp derivative trademarks are vastly more difficult to obtain. Next slide. And that's because on the day that the Farm Bill was signed, then acting President Trump signed the bill on December 20th, 2018. And Scott Gottlieb, who was the FDA commissioner at the time, put a simple statement. It's like 3-paragraph letter on the FDA's webpage stating, thanks, Congress. You gave us regulatory purview in the 2018 Farm Bill. By the way, we've concluded because CBD and THC are active ingredients in prescription drugs, under DSHEA and under the Food, Drug, and Cosmetics Act, they're ineligible to be classified as dietary supplements, meaning you can't sell any product in U.S. commerce as a dietary supplement if it contains THC or CBD, and you cannot add it to any food, drug, beverage, or cosmetic. Now, I'm sure all of our attendees know you can find these products freely sold across the United States, and the FDA has historically not been very active in enforcement. They go after companies who are making quite egregious health claims. But that doesn't help me if you're not making any health claims on your products, because there is nothing any trademark attorney in the United States can do to get around the lawful use bar. So the USPTO, instead of saying this product violates the Controlled Substances Act, which they'll still do, and you have to argue against that, they now will resort to this product violates the Food, Drug, and Cosmetics Act. And the only way to get around that is to show that you're using what's called a GRAS ingredient. And there's 3 derived from hemp, but nobody wants to use those because they contain minutia traces of THC and CBD. It's like the whole hemp seeds that you've been able to buy at Whole Foods for 20 years. Those are the only inclusive products that are eligible for registration, but for smokable products. So you can actually register hemp derivative smokable products on the register. Topicals, it is getting a bit more difficult for topicals because people tend to name their products, relief or, muscle soreness cream, something like that. That's a health claim. Anytime you're evaluating a health claim, you ask yourself, is this a normal structure function of the human body? And you would think the answer is, yes, it is normal to be in pain, but you ask yourself, would a perfectly functioning normal human being experience pain? No. Is my product claiming to fix that? Yes. That's a health claim. So the examiners are now really intensely reviewing the labeling and also the website claims that you make in accordance with these products. Actually, one examiner recently bring up a social media post. The company had posted a blog post about the benefits of CBD. I cannot argue. There's nothing I can do at that point to come back and say, nope, they weren't indicating that was a health claim, because that is what's considered an implied health claim. by the FDA. So in my opinion, that's why I say hemp derivative trademarks are a little bit more difficult to get through on the registry. And I know we wanted to leave time for sufficient and robust Q&A, so I'm going to turn it back over to Sean and Andrew to open it up for questions.
Thanks so much, Chelsea. Thanks, Eric. This is very fascinating, and I think a great place to kind of kick it off. So we had some questions in the chat. We're going to start out with some of the questions that Sean and I had put together, but some of these do mirror some of the questions that are in the chat. So if your question was at least half answered or so, we may end up jumping on to someone else. So, I know that there's a lot of concern, and there was honestly this is one of the questions in the chat as well about kind of generic patents and what is the risk. Eric had mentioned that there's over 100,000 patents on cannabis. We hear all of the time that if someone has a patent on something super generic and it's going to completely turn the cannabis industry upside down because everyone will have to pay them. So, Eric, I wanted to ask you, what's the threat that someone is able to actually enforce a very broad patent on the cannabis or psychedelic industries that monopolizes an activity or a process that's currently seen as kind of an industry standard?
Well, as you can imagine, there's a lot of layers and nuances to this, but in general, if the patent claims that would be at issue here are considered valid until proven otherwise by a court of competent authority. So if we assume that there's some on its face valid claim out there that is broad enough to disrupt what you're intending to do in the marketplace, then it's a matter of trying to figure out if that claim actually is invalid by trying to find out if there's prior art that would invalidate it, or there's other reasons it could be invalidated, like it wasn't properly described or enabled in the patent application. So there's ways to challenge it, but leaving that aside, it's going to be difficult for somebody at this point to get a claim that's going to be so overarching that it shuts down the whole industry. Because if anybody was publicly doing, in public use for what that person's trying to claim more than a year prior to the time that that person disclosed it, that's trying to patent it, then it would not be able to patent because it would be in the public domain. And so I put the onus back on the parties that are concerned about the patents that are going to watch the patent space. There's many things that can be done. For example, during the pendency of patent application and within certain periods of time, anyone can file third-party observations against a patent and bring to the patent office public art that they believe should invalidate that patent, and the patent examiners will consider that. And so that's something that can be relatively inexpensively done. It's time consuming, but it's worthwhile if you're very concerned about a particular technical space you're operating in, and you want to make sure you're not foreclosed. And after a patent does issue, there's post-grant patent challenges you can file, including at the patent office and then later at the federal courts. And so there's different ways to challenge it both before and after the patent is issued. But I would mostly say just monitor the space carefully and see what's coming out. But do remember, there's always an 18-month blackout period from the time somebody files a patent application until it's first published. And so we're always working somewhat blindly in that 18-month space until those patent applications or patents publish and we actually see, what they're disclosing and claiming.
Thanks, Eric. That's really helpful. Sean, do you want to ask the next question, or you want me to jump on? Yes, Chelsea one.
Sure. This one, I guess, is one more for Eric, and then I want to move to some trademark questions. But a question I get a lot in practice is as people are more interested in patenting different strains and different genetics and even seeds, like, is there significant activity in patents with genetics and seeds and strains? And can you speak to the viability of those patents and what you're seeing in the space?
Well, when I look at historically what tech areas are getting the most attention from the patent space, genetics and germplasm is up there, along with the agronomic practices and horticultural practices for growing and maintaining those plants and harvesting. So it is a very active area. And as I said, there's different ways that you can protect it, 3 different ways in the United States, and some parties are choosing one of those ways over another. And so with those 3 different options, then that gives more availability people to protect their germplasm and their plant genetics. Where I think it's going to become important going forward is in the botanical drug category. So if in fact they have a new botanical drug that traces back to a particular plant germplasm, then it's going to be extremely important to protect that plant germplasm and similar germplasms so that you can protect that pharmaceutical drug and its space. I think we're going to see an uptick in that area in general, both probably psilocybin and also in cannabis, as well as maybe in some other plant and fungi directed areas that involve similar kinds of ingredients. Let me think. I'm trying to think if there's anything else I want to say about that. I mean, Sean, do you have a follow-up on that or not?
Yeah, I mean, I guess at what stage should folks be pursuing? I mean, at the start of when they think they have a good genetic, what phase should they start thinking about patent protection and kind of the seed genetics realm?
Well, I think if they have a business model and a marketing plan built around a certain particular germplasm or plant genetics, then they should start thinking about, protecting that in one of the formal ways that we've discussed, because that will give them, some exclusivity in that area. It's generally somewhat easier to get patents around specific genetics of plants, because usually if somebody's combining new genetic combinations, it's not out there in the public domain, so it's probably novel and unobvious, and so therefore patentable. But it's also, somewhat narrow form of protection, and that it's to that plant genetics, right? But if that's the thing you want to sell, the thing from which you're extracting your product from, then it's very important to do so. Of course, there's other reasons. I mean, if you look at Charlotte's Web, I mean, they derive their commercial products from particular strains that they have protected by patent. And so even outside the pharmaceutical area can be important.
Thank you.
Interesting. Chelsea, we've got a great question for you from one of the audience members from Monica Sanchez. So does the unlawful use argument by the USPTO also apply to terpene products that are cannabis derived, even though the terpenes don't contain any amount of CBD or THC?
Twofold answer to that. Yes and no. This is when you have to go to the source rule. Are the terpenes derived from actual cannabis above 0.3%? Then yes, it's a controlled substance at that point. If the terpenes are derived from lawful hemp produced in accordance with the 2018 Farm Bill, if the product contains no CBD and or THC, it should be registrable.
Awesome. So that was quick. So I'm going to follow up with another lawful use question. So we'll rapid fire some of these. Someone was also asking about how this may or may not apply to a retail premises. So do you have to specify a cannabis retailer, or can you just register a general retailer? So tobacco accessories retailers and others for where your product might be sold.
I had the no reacting with on the can you just register a general retailer. You never want to commit fraud in an application for the United States Patent and Trademark Office. So they would consider that an act of fraud. If you were simply submitting and saying, hey, I'm a retail store, but don't disclose that, yeah, I'm actually selling cannabis, they're going to find out anyway during the review period for the specimen. But you do need to disclose that, but you would be wasting your money, because ask yourself, I am selling actual cannabis. What does the federal government consider that to be doing? Engaging in the trafficking and distribution of a controlled substance. So the actual retail dispensary services themselves, non-registrable for cannabis.
Awesome. Sean, you want to, thank you for the quick answers, Chelsea. We got a lot of them coming in, and so we'll keep this rolling. Sean, you want to jump on some more questions next?
Yeah, so I had one question another one that comes up a lot with respect to patents and incentives, and one that also is relating to just general incentives for research. And we have significantly more research on synthetic substances at the federally legal research level than botanicals, in part due to just the FDA framework and how it's built, and approval pathways, but also because of the patent opportunities. And do you think that the way the patent system is structured sort of incentivizes more companies to research and develop synthetics versus botanicals? And do you think any of that could change with rescheduling? Or do you think there's a real pathway for both and IP protection?
Well, I think there's a viable pathway for both in IP protection, particularly around patents, but I think the issue still goes back to the FDA, because they've only approved 2 botanical drugs to date, and neither of those were really easy paths. And so, some questions about, what the FDA will approve in the way of botanical drugs. I do think it's a very viable area. I think it's an area of great interest to the public too, because I think they like the whole idea of this symphony of effects and the combination coming from the plants and it being natural versus a synthetic chemical entity, which I think some members of the public are starting to have doubts about the viability of the single synthetic chemical entity going forward as being our answer to all of our health problems. As far as the patent system goes, I mean, the thing to keep in mind is it is designed to encourage innovation. I mean, the whole idea is, and it kind of gets back to an earlier question about if somebody could block it. And of course, there's always that possibility, but as we discussed, there's ways to monitor that. If a patent comes out or a patent application comes out that it causes you some concern about what you're going to do or are doing, then you innovate around it. I mean, that's how the patent system was designed, to reward those people that actually came up with novel and obvious ways to do things or products, and then encouraging others to design around those to come up with new ones. So I would think overall, to answer your question, this is going to encourage research and development and patenting around all of these areas that have to do with botanicals and also active pharmaceutical ingredients from plant products.
No, thanks. I agree. I'm a real believer in the pathway for both, and the entourage effect for naturals, and also that that's a lot of what the consumers are going to be using in the market. And with psychedelics and the state regulated program, they're generally, right now, mostly natural medicines and not synthetics. And then there are also, utilities to the consistency and reproducibility by synthetic substances. So I'm hopeful there is more of a pathway for both, following synthetics and more development. Adding a quick question from the audience, a clarification on a sort of broad versus generic. Can someone patent, for example, something like nano THC, and does that mean no one else can make it without the generic patent? And the audience question is making the analogy. It seems like if Doritos was to patent tortilla chips, that might be too broad. So how would that apply to something like a nano THC?
So nanotechnology is an area of increasing attention within this space, and there's a number of patent applications pending in that area, and some issued, not just around cannabis psilocybin, but around many other products also. And so it's a hot topic area. I mean, again, it gets back to if somebody has their earliest patent application priority filing date, if somebody publicly used that or even secretly sold it prior to their filing date by another, then that would prevent them from getting valid patent, a valid claim on that technology. So I think that it would be difficult at this point for somebody to get a super broad nano technology claim that's going to dominate the industry. Having said that, though, someone very well could come up with a very novel, unobvious way of doing in a much better way and making a much better particle, and in that case could get a patent, and it could then give them exclusivity in that area.
Thanks, Eric. That's yeah, it's interesting as it pertains to how to potentially defend from broad patents, which is if you're doing an activity, keep records of it. Of course, that's challenging when maybe those activities were illegal, or at least are illegal. So I've got a question that I think applies both with cannabis as well as psychedelics, since both of those markets will have essentially some component of legal sales alongside federally legal sales. So cannabis, some of them will also sell vaporizers, tobacco accessories, t-shirts, so forth. And with psychedelics, they will be providing therapy services in addition to psychedelic assisted therapy services. So, I wanted to ask whether or not, and this was, as well, one of the audience questions, whether or not there's an ability to trademark the name of the store or, let's say, the therapy center, if they have activities that are legal. Would you have to segregate those in certain ways? Would treat them as kind of different LLCs? Kind of what's the best strategy there for trademarking when a component of the activities are legal and a component are not?
So the good news is you don't have to bifurcate them for me. There may be a compelling reason from your corporate counsel to do that, but for trademark purposes, the examiner is limited to the record before them. They can look at your website, but for example, if you are a cannabis dispensary service and I'm applying for you in one of the eligible ancillary services category, and if you are a psychedelic or a cannabis company, don't be disheartened by my doom and gloom presentation. That is the reality. But presuming you have registrable subject matter, I can get you on in some form or fashion a good, I would say, 98% of the time. I may need you to take an extra step for me, like put an informational page up on your website for consumers so that I can get you into an eligible category. But that's simply a matter of, if you come to me as a potential client, we sit and I help educate on what are some of the potential pathways to registration and which one fits best for you that we can work towards. So therapeutic services, you're actually just providing the services at that point. A lot of times the trip sitter will not be the one who is actually making the sale of the medication. There generally is bifurcation of the entities at that point. So yeah, I can register trip sitting services easily. I can do your dispensary services for again, informational websites, your tobacco accessories. Most cannabis companies will have a vaporizer, a lighter, rolling paper, a pipe, something that you sell within that dispensary. But make no mistake, it's not the simple act of selling it that is creating the trademark right in that instance. The actual mark that we're applying for has to be on that product. So if you bring me, a simple Bic lighter that you can grab in the checkout line at Target, the answer is no, I cannot register that. If you bring me a branded lighter that has your dispensary's name clearly displayed on it, and presuming there's no other bars to registration, and what do I mean when I say that? Somebody else hasn't already claimed it and has priority in that instance. You're not violating one of the specific bars that are within the Lanham Act, such as, geographically misdescriptive. You can't call your company, Florida Bud if you're located in Wisconsin. You're going to get a refusal at that point because the consumer is obviously going to think they are purchasing cannabis that comes from Florida. You're going to, that's one of the many reasons that you can get for refusal. But that's part of why you work with a trademark attorney, because from our very first call, when you tell me your mark, I will almost nigh immediately be able to tell you, is it registrable per se? So what I'm looking at when I say that, when it comes to trademarks, we use what's called a sliding scale of distinctiveness. So literally imagine a scale here. First, we start with generic. So if you are an Apple seller and you want to call your company Apple, I'm going to tell you there's no way that anyone in the entire world can get that through with you, because that's generic. And the reasoning behind that is that every seller of apples needs to use the word apple to describe their product. So you're never going to get exclusive rights on that. The next up the scale, and this is where we tend to see people focus, is merely descriptive. And that's where you are picking words that merely describe exactly what you're selling. So let's take the apple seller again. If they call it Golden Delicious and they are selling Golden Delicious apples, I mean, that's bordering actually back on generic. So let's call it, fruity, golden, delicious. Still merely descriptive. You're describing an ingredient, characteristic, quality, or component of the goods or services right there directly in the mark. And cannabis companies, man, this industry loves its generic trademarks. And I always tell my clients, like, look, in the event of potential full legality, or even just within your own state, if I'm sitting there looking at an entire row of brands that are all green this or trees that or buzz that or high this, how are you distinguishing yourself? The next bump up, so try to avoid merely descriptive. Next bump up on that is what we call suggestive. So think copper tone for sunblock, or tanning oils from Copper Tone Company. Why is it called copper tone? Because you're trying to get copper tone when you go out there in the sun. Then you move up to what we call arbitrary, where is you take a completely normal word and apply it to something it has nothing to do with. Prime example of that, Apple computers. What in the world do computers and phones have to do with an apple? They took a normal word, put it in a new context. And last but not least, we have fanciful marks, which are completely made up words. So Haagen-Dazs. A lot of people think Haagen-Dazs actually means something in German. It doesn't. They made it up. So that scale, the farther along you go on the scale, the higher the protectability of the mark itself. Any court in review is always going to start with, where does this mark fall on the spectrum? How strong is it? So you always want to be, the best place to be is suggestive and onwards. Merely descriptive marks can often earn some favorable litigation. I don't want to get too much into the weeds, but some evidentiary considerations when they become incontestable, which means 5 years of constant use in U.S. commerce, such that consumers recognize that brand. So think the Louboutin Red Sole. 20 years ago, if you saw a red sole walking down the street, you probably wouldn't know what that is. You do now. That's secondary meaning. It's become so large that consumers recognize it. So that is always the first question. Don't look at the subject matter first of, do I have the vape? Do I have the what? We always start with, do you even have trademarkable subject matter? And if you do, despite whether you're cannabis or psychedelic or hemp, again, there are pathways to registration of that.
That's fascinating, Chelsea. Thank you. One of the things I wanted to follow up, this is, maybe a little bit of a clarification from the slides that you presented earlier as it pertains to trademarking for hopefully Schedule 3 cannabis pharmaceuticals. At what stage in the process would you need to be in order to get that trademark, right? Like, let's say you're a cannabis company and you haven't even applied yet to turn one of your products, let's say an edible product, into a pharmaceutical. Could you apply for a trademark? Do you have to be kind of in the process of pharmaceuticalization, I'll say that, for the purposes of trademarking, or what's kind of relevant as it would pertain to a Schedule 3 edible?
To be candid, I do not know. And that answer is very specific to cannabis. And here's why I say that. In the United States, we have two forms of applications. We have use-based, which means you are actually selling the good or service in United States commerce. You have made a sale or offered the service across state lines to another customer. We also have the 1B application, which is intent to use, which is what we call a placeholder application. You sign under penalty of perjury that you have a bona fide good faith belief that you will be using this mark in commerce within a set period of time. So the pharmaceutical industry, and this is a very astute question because it goes right to the heart of the dispute that was at Emery Joy T, the case I was talking about that I was so excited about, that fizzled out. In the pharmaceutical industry, when a pharmaceutical client comes to me and they're in drug development stage or looking at a potential drug, those companies can file 10 to 20 applications to act as placeholders for those names. Even though they haven't gone through full clinicals, they haven't been approved at that point, they have nothing from the NDA, they may have filed, the FDA, they may have filed their IND or commenced clinicals. But the belief is, well, eventually we'll get a pharmaceutical drug at the end of this, and then we'll pick the name. Historically, cannabis companies have been denied that, and that was the very basis of Emery Joy T. You saw an applicant who it was a hemp-derived mark. I think they had a THC or a CBD, and their position was, we're filing an intent to use application. We know it's illegal right now, but we have a good faith belief that by the time the intent to use application window runs out, and generally the office is, you're waiting on an assignment to an examining attorney anywhere between 12 to 18 months at this point. So you have a good year just to wait. Then when one's assigned, you're going to go through office action simply because of the subject matter. And then I can file up to 5 extensions, getting you nearly 3 years. So sum total, I can usually buy you between 4 to 5 years. So in Imre Joy T, the litigant was saying, I have a very good faith belief that within, 3 to 5 years, there will be a lawful pathway. Either Congress will fix the FDA prohibitions, or for actual cannabis goods, we'll have rescheduling. But the office denied it and said, nope, cannabis Schedule 1 cannot do it. So that was the entire point of that case, was the kind of the disparate treatment between the industries. Again, that really goes back to the threshold of the lawful use rule, which I think is an illegal rule, right for challenge. If anybody would like to take that all the way up to Supreme Court, shoot us a call after this.
Thanks, Chelsea. That's fascinating, because it may seem that some of the underlying basis for that denial might be different if it's Schedule 3 versus Schedule 1. So again, more hopeful litigation to make the structures of this a little bit more palatable. Sean, you want to jump on some more questions?
Yeah, so there's one in the chat that I think is important, because I think it's the practical realities of the patent process, especially in cannabis, aren't always understood. And I know it's quite the clogged docket. How many years would you estimate it takes to review a patent? And what can folks submitting patents expect as far as even getting an examiner or review time?
Well, of course, and I think the audience probably knows this, but it's worth stating that, filed a provisional patent application, that doesn't get examined. That sits there up to 1 year in secrecy at the patent office and acts as a priority date for you to then file a regular US or international application in which you actually get examined. And so that year doesn't really count towards that. Now, if you file a regular US application, not a provisional, it generally is between 2 to 3 years before the examiners pick it up and give it a full examination. But you can control that by filing for expedited or rapid prosecution. You pay just a little bit more extra money, moves it to the top of the line, and it moves through the patent office quite quickly. We've gotten notifications of allowance sometimes within 3 to 9 months after we've done that, and sometimes we've gotten grants within a year. So you don't have to wait if you don't want to. Now, very similar to what Chelsea was talking about, many of our clients do play the waiting game on purpose for a whole bunch of reasons, and they don't want their patent applications to go through the patent office really quickly for a variety of reasons. But if you really want to move yours to the head of the line, I would absolutely recommend you look into the fast tracking the application at the US Patent and other patent offices. Some of them have something similar. The money you spend on that, which is not that much to get that special status, is more than made up in the less time you need later for attorneys to handle all these office actions down the road, because the examiners are really committed to these fast track applications. Pick them up, give you a call, talk to you, and it moves forward.
Thank you. And Chelsea, what about with trademarks as far as timeline and the process?
Phenomenally backlogged at this point. I mean, even on a use-based application, from the time period from filing into registration for this particular subject matter, hemp, cannabis, or psychedelics, you're looking generally at about 2 years, and that's on a fairly fast track. And to be candid, it's only getting worse. We've gone from 6 to 8 months to 8 to 10 to now 12 to 18 months. And it's also dependent on the individual examiner. Once the application is assigned to the examining attorney, they may be very thorough and efficient and issue an office action for you later that week. It may be 4 months before you hear anything from the office. The office did recently shorten. I'm not sure it was the best decision. I don't really understand the logic behind it, but their theory was that if you shorten the amount of time that you have to respond to an office action, previously it was 6 months, that the examiners who were already overworked will have some reduction in their workload. So they shorten the time period to 3 months, which means they now have more things to review in a much shorter time period. And that is, I think, contributing to this backlog as well. Now, I will also be very candid. 5 years ago, when companies came to me and said, hey, can we get this through? My answer was usually, yeah, 99.9% sure, we'll have no issues with this. Now I tell people, I can never guarantee you anything in the process, but what I can guarantee you at this point is 99% of the time we will receive an office action. It used to not be that way, and often, especially since the deadlines have been really abbreviated, I find the examiners are not, I don't want to disparage examiners here at this point. They are not granted the time from the office anymore to properly review responses. Some offices can be quite substantive. I filed a response the other day that was nearly 350 pages. Now, granted, a lot were evidentiary attachments, but they were pertinent evidentiary attachments responding to the examiner's points that they raised. And then we got pretty much a verbatim office action that clearly the merits weren't really assessed on that. So there are mechanisms. I generally tell people, if you're a cannabis or psychedelic company, count on an office action. We're definitely getting one, and oftentimes we may need to follow up with an appeal filing, which 99, I should say about 95% of the time, do not move forward. The examining attorney will find a pathway to mechanism. You do what's called a contemporaneous filing at the lower level with the examining attorney. I file what's called a request for reconsideration, where I'm re-arguing the merits, saying, please reconsider this final determination. At the same time, I file a notice of appeal at the Trademark Trial and Appeal Board. And a lot of times the examining attorney will look at that and say, I am so busy right now. I really do not want to deal with a year of briefing this. So unless it's something they're terribly, terribly passionate about, usually you will find that that helps move the needle.
Wow, no, that's good to know. I knew it was backlogged, but I didn't realize the gravity. Well, I know we're at time, so thank you both so much for your time and wisdom, and to the audience for your great questions and thoughtful discussions. And I know we didn't get to everyone, so feel free to follow up with email if there's anything we didn't answer. And we hope to have more IP discussions, especially after any scheduling developments with any of these substances. So thank you so much, and we have the emails up here for follow-up for everybody. Thanks, guys.
Thank
Thank
you
you.
all.